Okay, so I have discussed about the pre-grant prosecution. Okay, so just like say, what will be the steps involved to get the patent in the form of a certificate. So your task is not complete after getting the certificate. Okay, so then also you have to think about just like say different steps you have to steps are involved. Okay, just like say you have to give a statement of working of your patents. A statement of working of your patents have to be provided. Just like say every year you have to provide a statement of working of your invention, because the patent is for the government has provided or state have provided the patent right to you based on working of your working. Just like you will, they are considering that you will work with your invention where, let's say if in India patent, so in India. So for that reason the government is also taking a check whether you are working of your patents or not. So every years you have to renew your patents and also give a working statement of your patent. So working of patents, working of patents, working of patents of patents. So what do you mean by working of patents? Okay, working of patents means, let's say you have got a patents. So now you have not yet sorry, you have filed the patent applications, but just like say you have now started to form a startup, just like working of patent, working of patent. You have one now to create a startup. Now so you try to create a, so how can you work? Create a startup, give license, sell, assign. Okay, or create a startup, sell, assign. So these are the different routes by virtue of which you can work about your invention, or you may refer that okay whom you are given the license or whom you have sell your patent, whom you have assigned the patents, or if startup has formed, then just like say a startup is formed and then a startup how they are using. So every years you have to give a working statement of your patent. If you are not working of your invention, non-working lead to the maybe revocation of your patent. Okay, so what are the things you have to follow? You have to work with the patent. So working involves just like work with you, just like work does not means a commercial, means even also research work, but it is only for a commercial purpose. I would refer that is industrial applicability. So you create a startup company, then a company like this way, then you may give a license to another company. Your invention will fit somebody's product portfolio, they will take the license, licensing, the licensee will work, you are the licensor. This is also working of your patents. Now if you sell, now you have the already sell the rights, means now the patent, who will be the patentee, to whom you have sold, he will be the patentee. Okay, so this thing will be reflected. If assign, the assign will be the patentee. Now he will give the statement of your the working of the invention. So now the rights, the name owners will be the buyer, owner will be the assignee of the invention, but licensee simply the permitter, permission by virtue of some legal instrument. You are giving permitting somebody to use the invention, so licensee. So in this case, licensee will not give the licensee will not give the statement of working. The licensor means the person who is the patent holder will give the working of the invention. A startup means if the inventor himself created the startup or applicant is gives the startup, he will give the because still ownership lying with him, then he will give the statement of working. So you got an idea, the statement of working component, working of the patent in India means not in India. So that's production or working in India. Okay. So, some cases you may refer that okay, production unit is Bangladesh and here you are simply selling, that may also treated as a working of the invention in India also. Okay. So, working of the patents you have to provide, then you have to renew your patents. Okay. Just like you file a patent applications, fees you have paid, you file a request for examination fees also. By virtue of that you got the patent, maybe let us say 4th year. Then after 4th year, every year till 20th year, you have to pay the renewal fees of your patents. The renewal fee is also, if you consider renewal fee is like this way, maybe first year renewal fee is like this fee, let us say this is a fee, this is a year wise renewal fee, then second year will increase, third year like this way renewal fee until 20th years will increase on that way. Okay. So, renewal you have to every years you have to give a working statement, you have to renew your patents, renewal you have to renew your patents. Okay. So, now there is also another procedure. If you thought about that, okay, I forgot to renew the patent for let us say second year, but there is a procedure when means act has suggested given some window period, within a window period you can restore your, let us say to in the second years say renewal fee is supposed to be paid in December, but you have not paid because let us say you are not getting proper licensee, you are not sure about that say seed investment, capital investment. So, you are not working with the invention on that cases. So, you have not maybe also intentionally you have not renewed the paid the renewal fees, but till some way after that you got some investment, you got some licensee, you got some capitals. So, in that cases you want to restore your rights. So, there is a procedure called restoration. You have to restore your rights stating that okay my intention I am not say intentionally not paid, my intention say not like that, say I was unintentionally so intentionally I have not missed the renewal fees, unintentionally that I say I unintentionally I have not some of paid the renewal fees now, but I have now I want to restore my rights with reference to that patents. So, then you can go for restorations, you can go for you can restore your rights. So, okay. So, restoration is one of the part restoration. So, restoration is the another part that you can restore the your rights. Okay, restoration you can restore your rights by within that time frame, then it will be restored. If you do not restore within that time frame, then your patent will be abandoned. So, what do you mean by abandonment? Then with that you do not have any right on that patents. Okay. So, that will be abandoned. So, you may consider that may lead to the abandonment means no rights, then it will be considered as a patent, it will be considered as a public good. So, the steps involve working of patent, renewal, restoration. Then another part is important here, that amendment. Okay. So, now during the course after the getting the patent, so any amendment with reference to the name of applicant or amendment with reference to specification without changing the scope or content or scope of the invention, that is you cannot enlarge your rights. Whatever right have been provided based on the date of filing or complete specification, that you cannot further enlarged. So, within the same scope you may go for amendment or your amendment with reference to the name of applicant, a name of patentee, that is possible in the Patent Act. If you read the section 57 of the Patent Act, they have given the scope or limit of the amendment with reference to the patent. Now, it is a patent. Earlier it was an application, now we got the certificate means patent. Whatever the amendment is permitted in respect of the patent, in respect of the patent, including the patent patentee's name and also content of the specification, that scope is limited and discussed in section 57. Generally, your amendment should not, so generally means not like that, amendment should not again further give additional right to you. So, the amendment, okay. So, you can do a amendment by the before after grants, before grants also can be possible, after grant amendment we are stating about. So, amendment using the section 57, amendment with reference to the applicant say patentee, with amendment with reference to the specification content without changing the scope of your rights. So, these are the amendment is also possible, you can go for amendment. Then another important parameter here, patent of additions. Patent of additions. Patent of addition is another important parameters. What do you mean by that? I will try to explain that component here. Patent of addition. Okay. So, patent of additions. Okay. So, patent of addition. So, let us say you have an invention. Okay. Let us say you have an invention. What I let us say consider your invention with reference to a chemical. That chemical is used for, let us say again let us consider biochemical. That chemical have a potential for let us say for generation of some energy. So, now that your invention is a chemical with reference to generation of some energy. By subsequently you have made a modification or improvement with reference to that chemical. Maybe let us say that chemical in that chemical you have used Mx, and X is with reference to let us say halide Cl. That time you have not thought about iodine or say fluorine or some other halogen also, let us say instead of halogen you are thinking about other radical also. So, X part initially limited to chlorine and even you have not claimed the all halide groups. So, now you are thinking about the improvement with reference to the M, means MCl instead of MCl you are considering MI or MOH. So, you are improving because MOH you are getting that improved property over MCl, MI having improved property over MCl. So, then you are giving some improvement or modification, you are doing some improvement or modifications. So, that improvement and modification is definitely new, that improvement or modification is definitely new. So, that improvement and modification you want to protect, but you may ask me whether improvement and modification I can protect by means of amendment. No, by improvement and modification is not within the scope of your earlier invention. So, that improvement and modification can come up by virtue of patent of addition. Okay, people do not have a knowledge about the patent of additions, do not use that part specifically. Although this is pros and cons are there with reference to patent of additions, but improvement and modification can be protected by means of patent of additions. Okay. So, if you ask me what are the criteria, whether patent of addition again required to meet the criteria of patentability, I will say no, but patent of addition should be improvement and modification should be new, but does not require to fulfill the criteria of inventive steps. Okay. So, just like MCl and other person also can thought about MI, but you are the person you are trying to make a modification or improvement. Okay. But let us say you may ask me if somebody can come up with MI with reference to the chemical and file an independent patent application, you can file a suit against the person on the grounds of inventive steps. Okay. So, now if you file if you come up say if you come up with MI, that you can go for patent of additions, filing a patent of addition. So, because patent of addition means criteria of inventive step does not require to fulfill to get a patent of additions. Okay. So, patent of additions does not require to fulfill the criteria of inventive steps. Okay. It may be obvious to the person skilled in the art, but you are adding a features with reference to your own patent. Okay. So, this is the utility of patent of addition. Improvement and modification you are protecting by means of patent of addition. When you file a patent of addition after getting a main patent. So, then who can file patent of additions? Who can file the patent of addition? Patent of addition will be filed by the applicant or patentee of the main patent, applicant or patentee of the main patent. Who will file the patent of addition? Applicant or patentee of the main patent. So, what happened to the inventors? Inventors may ultimately communicate to the applicant, who applicant is the assignee, or he may communicate to the patentee. Then there will be, because the agreement will suggest any improvement and modification, again you have to assign back to the assignee or the patent assignee, who will be considered the applicant or subsequently the patentee. Okay. That agreement should be clearly stated. So, understanding that inventors can also improve, but ultimately the improvement has to, or modification has to be filed by the patentee or applicant of the patent. So, now advantage of patent of addition, you are protecting the improvement or modification in the patent of additions. Then the time frame of the patent of addition, time frame is the important part. So, let us say main patent, say patent A, main patent. Okay. Then say let us say it will protect up to 20th year. Okay. So, after getting the patent A, means main patent, within 20 years time frame, you can file a number of patent of additions. So, patent of addition has to be filed within 20 years, means within the lifetime of the main patent. Okay. Within the lifetime of the main patent, you have to file the patent of additions. Okay. So, now advantage means, let us say your initial rights was that, now your rights has increased, maybe the modification part is enlarged rights for you. Now, enlarged rights, but the main you are not getting additional time frame. You may consider this is the disadvantage. Okay, you let us say main patent is filed in 0th month, patent of addition is filed in 6th year. So, the life of the patent of additions is only for 14 years, means 20 minus 6 means 14 years. Okay. So, patent of additions will ultimately sometime we call that life, means when the main patents will die, along with the main patent, patent of addition will die. But one important features is there, let us say somehow main patent revoked, I will come, or somehow main patent revoked, means let us main patent say, and also another advantage is patent of addition, if you renew the main patent, automatically patent of addition also will be renewed. But situation may emerge, say patent A somehow be main patent may revoked because of some grounds. So, revocation I will not explain yet. So, revoked, then patent of addition will be independent patents, but the life will be the life of the main patent. Advantage, patent of addition will be independent patent when the main patent get revoked, but the life will not extend by virtue of that. Life will be life of his main patent, life of the main patent. Okay. So, the improvement or modification can be protected by means of patent of additions. Improvement or modification will be protected by means of patent of additions. What the thing? Improvement or modification will be protected by means of patent of additions. Okay. Patent of additions. Okay. So, now this is you got the idea of patent of additions. Okay. Patent of additions. Okay. So, now other part is the transaction, that part I will discuss later on. Transaction, whatever the way you can transact with reference to the patent. Then I have not discussed the revocation. Okay. So, now you have already got the thread of pre-grant, post-grant. Now, again you have to be cautious about the revocations. Okay. So, now the revocation can be done by the say patent office, government, and also, so revocation can be done, who can revoke? Revocation means revocation of title you may consider, means abandonment of rights with reference to that patent. So, who can consider revoked? Central government we may refer at central government, or any persons can also revoke your patents. So, central government, let us say you are not working with reference to the patents, or somehow you are increasing the price because of the monopoly rights you have on that patent, you are increasing the price of the patented product. Okay. So, or reasonable need of the public is you are not meeting. Okay. So, on that ground, when government may have the privileges to revoke your patent. Okay. Or you are not working with the patents. Not working means say not working lead to the revocation, or you are not providing the patented article as required by the public. So, that lead to also a revocation of the patent, means your rights will be revoked. So, who can revoke? Central government revoked, and the persons can also revoke on the grounds again, just like say your invention is not novel, not inventive steps, all that ground again may come up on the ground in respect of revocation. Just you remember that we have European Patent Office, we have revoked the right of the that you may revoke the right of revoke the just like a wound healing property of Haldi, patent related to wound healing property of the Haldi, we successfully revoked in European Patent Office, because let us say wound healing property of Haldi was our traditional knowledge. Considering this was a prior public knowledge in India, we have successfully able to revoke the patent application in Europe also. In Europe also, you will have able to successfully revoke the patents. Okay. So, the revocation again is coming the grounds of novelty, inventive states, again coming when the persons will use that tools for revocation. Central government use the tools of revocation for the need of the public on the grounds of non-working and others. Okay. So, revocation is another threat for you. Just like for a patentee, you may have to, although very less number of incident in India, but you have to be you have to consider these situations also. Then another important parameter we may refer is a compulsory license. Okay. So, compulsory license you may consider as a mere permissions, but compulsory license say means just like say consider a situation compulsory license compulsory license. Compulsory license. Okay. So, consider a situation, a particular drug, company A having patent, company A having patent with reference to a particular drug, let us say drug with reference to the cancer drug. Okay. So, now he has a patent. So, now what he is doing, he don't have enough manufacturing capability, and the drug is required, let us say we required a drug in the market, and you know that economic suggested economic or price escalation may happen if there is a demand supply gap, and few cases the company A intentionally is trying to create a price escalation to ultimately use his monopoly power in the form of a patent. Okay. So, then in that situation, company B may approach the company A, some cases he may deny it the company A, because he want to enjoy the fruits of escalation, because he want to use his patent right as a monopolistic rights, that is although anti-competitive, he want to use that part. So, he may deny the license of any other company who having the manufacturing capability with reference to that cancer drugs also. Okay. In some situation, even government may give somebody else to manufacture that based on a license from the company A itself. Okay. So, the situation when compulsory licensing tool or instrument will be used by the government, or you may consider the patent office, when there is a say demand supply gap, national emergency, the monopolistic power, the patentee have been using his monopolistic power, that lead to the price escalation, that led to the demand supply gap. So, to curb the monopolistic attitude of the patentee, so then government use the compulsory licensing tool. So, they use the compulsory licensing tool to curb the monopolistic power of the patentee. What they will do? So, now in that situation, let us say he denied the license, company A denied the license to company B, then they can approach the government, means patent office, and then patent office will ultimately negotiate between the company A and the company B, whom the company A has denied the license. So, so then they ultimately decide some amount of consideration by means of money. So, in this case, two situations may arises. Let us say company B approach the company A, but company B say also may be charged a huge license amount, license fee in the means of for consideration. In that grounds also company B can approach the government or in the form or IPO that he is a denial, he is charging exorbitant amount of money for license, or if he even denied the license. So, two situation, denying the license, or another situation he is charging exorbitant amount. In that situation also he can approach the government for, so that government now arbitrate or negotiate between the company A and company B, and they will ultimately say you may consider and say ultimately tell or state the company A to give the license to company B, and license fee will be decided by the government. So, we will decide the license fee now, the government will decide the license fee. So, in this case the situation when the company is denying the license to company B or charging exorbitantly. In another situation may arises that government need that medicine, and some company, another company has the manufacturing capability of that medicines. So, in that kinds of situation also the government can state and tell the company B to give a license to that company who has the manufacturing capability of that medicines. So, in that case government can also give negotiation, decide the license fees. Okay. So, the compulsory license does not means say free license, or the compulsory license means that a tool to curb the monopolistic attitude of the patentee. It is a tool used by the government to curb the monopolistic attitude of the patentee. It is a tool for the public benefit, so that monopolistic power of the patentee somehow be cut by use of these tools. In India, till one NATCO case is there with reference to the compulsory licensing. Okay. The bird flu related incident. Okay. So, now what are the post grant say prosecution you have learned now? Working of patents, renewal, okay. Then restoration, then patent of addition, okay. Transaction part I will discuss subsequently, amendment, revocation, compulsory license. So, these are the different things you have learned about the post grant prosecution. So, pre grant prosecution, subsequently we discussed about the post grant prosecutions, means after grants also you have to learn know about all those things. Okay. So, let us say you have learned what will be the your workflow regarding patent in India for the 20 years period where the office has involved. Okay. So, I am stopping it here now. We will continue discussion subsequently.